Hello. Hello, my true crime lovelies. How are you? Oh my goodness. I've seen some of the hearing today, like not the entire thing. I watched a little bit with, I think it's Coffee Cafe. I think Jenny is her name. And then, child, I was all up in Sarah's business. I didn't even make it to physical therapy. I wasn't feeling well. I am catching a cold. So I was like, there's a lot of old people in physical therapy. So I did not want to go in there I had a mask on, but I wanted to be respectful. So anyway, even if you guys have seen it already, I thank you for coming to watch it with me. If you're on the replay crew, I appreciate you too. Look who else is in the break room with us. There's little Sugar Bear. I tried to occupy him. I gave him some blueberry pancakes and some fresh blueberries. He ate them like that. So I just want to tell Judge Koenig off top, I'm doing the very best that I can, Judge. All right, let's get into it. Let's not dilly-dally, shall we? And I did get premium, so we should not have any hiccups. Here we go. Actually, I want to be down here. Let's start off with the full screen so we can get the full effect. We got Sarah coming in. She is coming in fully shackled as they said she would. We got our girl there with the lashes. She does not have the big glasses, but come through. She's got fresh eyelashes. Okay, sis. We see you. All right, let me see. Oh, come on. My little Mac is doing something weird. Here we go. Let's get started. Hopefully you guys can hear me. Drop a 1 if you can hear me. Shackles are coming off, or cuffs are coming off. Shackles are coming off. Yeah, she's put on quite a bit of weight since her arrest. But I hear that happens, right? People get carved up. Thank you, Nico. Hello. Oh, South Dakota. Welcome, welcome. Uh-oh, my son is playing with the curtain. Is the court making sound or is that just me? Hold on. Let's see. Is the sound? Yeah, sound is on. I don't want it to be too loud. Let me just skip ahead and make sure. Somebody move
the balance of the thing.
Okay, there we go. We'll go to where he's going to do roll call.
The certificate of service reflects the 13th, but the filing information is of this morning. All right, Ms. Fugate has, I am pronouncing your name correctly, am I not?
Thank you. That is the attorney for
copies of those motions. So Ms. Boone, if you
that is the attorney for the Miami Herald, and we went over their motion last night. In addition to that, technically they e-filed it last night, but it didn't show up in the court docket till today. So it's like the Orlando Sentinel, I believe. So she's representing them in their interest. They basically just tagged on to what the was it not the Miami Herald? That was the case. Oh my God, WFTV. So the Sentinel tagged onto WFTV, which is why they have the same attorney.
If you'd like to take a look at those, feel free to take your time to review them. And then after you've reviewed them, I may have the opportunity to answer any questions you have about them if I can, and then we can proceed.
So because and I said that last night, even with the first one, right, WFTV, she wasn't going to see it because they filed it on the 13th, which was yesterday, and she's getting hers by mail. Oh, they muted her.
If you want to provide those to
Hey, Wendy.
Ms. Boone as well, you
Alaska.
can do so. Thank you. State, do you need a copy?
My manager is going to Alaska.
All right, thank you, sir.
I got to get out there. I have uncles that used to work on the fishing boats back in the day. They'd go up from I grew up in Fresno. They go up from Fresno, California, get on the boat and be out there like all summer. So she is not prepared for this. One, I don't think she's prepared an argument at all. I think she just thought, like she did previously, she could pitch out emotional things about why it's not fair. But they definitely rode her hard. And the captain is here, and the captain's lawyer, Captain Gina DiGiovanni. I'm gonna make myself bigger while they do. Oh no, am I? Here we go. While they do all that, she's just reading these motions. Basically, the Sentinel came in and said, we are adjoining ourselves to what WFTV TV9 has already put in, as they are also an interested party and would like to fully cover the trial. So I'm sure they're throwing out case law. You guys know, we read it last night. Now, she did have the name of the case law, the Miami Herald versus Lewis case. I don't know how like they're set up. Like, can she look that up? Like, she has access to some law library because she was giving us all those cases that were from different states. So if you look in the bottom right of the screen, you can see a female officer laughing. Oh, really? Okay. When it comes up, please let us know. Lord. I think she was like knocked back, right? How did you say it? She was caught flat-footed. She wasn't ready. She wasn't ready. But I feel like this will be more indicative of how she's going to perform at the trial. She's snapping back at the witnesses, telling them they're not telling the truth or they're misunderstanding. It's like, ma'am, I'm going to need you to get it all the way together. What time is it in South Dakota and what time is it in Alaska? Okay, here we go.
Yes, ma'am.
One of my topics of discussion, as you know, are the requests in regards to the laptop.
Not a topic of discussion. It's a motion, ma'am.
But I have had access.
Oh, it's 5:30 there. Okay.
Not had to sit here.
So you guys are 2 hours. Can you hear her okay?
A major violation to my due process of me not having these in advance. To prepare properly and to utilize the court's time, and everyone else is here by me having to do this now. So I wanted to put that out to you that I am unprepared for this. I did not know that I had a statement to prepare, as everyone else did also prior to being here.
Ma'am, you were provided the case law as you had requested at our last hearing. It was mailed to you. You asked for the case law that the court was making reference to. You specifically asked for it. That was provided to you.
That was Friday.
It was mailed to you.
Case law?
Yes, ma'am.
Yes.
What was the date that it was mailed?
August 9. What was provided to you on August 9 was the additional copy of the pro se packet as provided by the Justice Administrative Commission.
We read that.
You were provided a hard copy of that in court, along with.
Okay, Nico, is it a little bit better now?
Case law that was referenced at the August 9 hearing. The court had said that it had reviewed in anticipation of the hearing that we were having this afternoon.
I don't have that. The thing that I was provided was the provision of witness list from the state.
That was handed to you.
Those were both provided to you in court. You are correct. The balance of the things that I'm speaking about were mailed to you at the legal mail address on August 9.
Which I have yet to receive.
Okay.
Okay. Should have kept an attorney.
Now, with regard to
I mean,
first time I'm seeing each one of these documents.
Last
I
hearing,
understand that.
he's going to print them out for
They
you,
were filed
sis.
August 12th, and unfortunately this morning, due to an issue with the e-portal,
I wouldn't have internet access.
Yeah, he
they were
knows
sent to
that.
you via U.S. mail as well.
Yesterday.
Yes.
Last hearing, she walked in with the motion, right? Or she walked in with that letter to the
So
captain.
you're not wasting the court's time. You can feel free to review those at this time.
There you go. Which is fair because it just was e-filed this morning. So it's not like she's been missing it for days.
Is this the case law you're referring to?
Can you read this book?
I believe that those are the circuit court opinions that are referenced in WFTV's motion,
No.
which cite to the Miami Herald versus Lewis decision, which is the controlling law on this matter.
Oh my God. He wants to pull my hair. Don't pull mommy's hair. It's not funny.
Use your mind to take.
Yeah. Okay, how do I get back to? Uh-oh. Hey, Jane, how are you? Okay, you can hear it better, and I'll just remember not to talk too loud. I'm a little hard of hearing, so sometimes when I get excited, I get loud. I need 3 ibuprofen. Just Sarah's word salad. Oh, you and me both, sis. You and me both. Good Lord. The gray rocking. Yes, I saw that on someone's channel. I agree. I totally agree. That's why she wrote in her letter. Hold on, my Google is going crazy.
Got it. I'm stopping any alarms and timers that are ringing on your smart home devices.
Remember in her letter when she was upset about the surprise hearing, and she wrote, he sat there with his nonchalant attitude because she's baiting him, right? She's trying to get a reaction. She's telling him things he already knows. She repeats herself, and he just does that gray rock, and I love it. I'm here for it. She's the judge. I mean, he's the judge she needed all along. Judge Wooten was like too, I mean, he was good for the time, right? You know, it was everything in its own time. But Kranick is gonna bring it in. You hear me, Kranick? Go ahead back there on that side and enjoy your Dr. Pepper. I see nobody has responded to that inmate seeks attorney poster. We made it as big as we could. I don't know what else to do. Oh, yes. Thank you. I will give him some little kisses. You want kisses? Up. Okay. He's sleepy. I'm trying to keep him up for longer. So he used to come home and take a nap, but I'm like, let me keep him up for longer so that he'll stay down longer once he finally goes to bed. He's already eaten. He had the pancake. That's what he wanted. Blueberry pancakes and blueberries. Yes. Yeah, definitely trying to bait him. Which I'm sure she did to George. Now, I'm not making any excuses for anybody hitting anybody, but I just think he both of them I think had some bit of arrested development, right? Like emotionally, because she's still having tantrums at 46. But I just think he couldn't handle it.
So much that I can do just not receiving these. Have any opportunity to look up any case law of my own.
You had opportunity. You knew what was going to be discussed today.
You can proceed, ma'am. What is it that you'd like to tell me about your concerns regarding the September 3rd evidence viewing that's been previously scheduled?
So I just got it. I have the
My concern
30-day
is regarding my
premium.
case and the
So it's going to be worth every penny right
alleged
now because it's
evidence
0. But on
is not already on
9/11,
the internet or posted anywhere on social media. And I'm wondering what the reasons for the court.
wait. Phoenix turned off my mic. Hold on.
Other
Sorry, the baby hit the.
sensationalism and exploitation.
I'll go back a little bit.
This would be for them to watch me look at the remaining bit of my evidence that has not been.
Okay, we're going to get it together. I loved that too. I loved the lawyer for the jail altogether. He was not having any of the foolishness, not one bit. Thank you, Karen. Yeah, I put some little Easter eggs in there. Ouch. If I'm bald tomorrow, you guys know why. Phoenix. Okay, let's mute mommy. Hold on. her mind is racing. She's like, he's not falling for it. He's not responding. He's not going to give me more time. She's stalling. So like, what do I do? Now she's looking at him. Are you done, ma'am? Just start your argument then. Your Honor, whenever you're ready. Well, thank God she got her shackles off, though. She can move all these papers around. I can't hear her. She gonna keep saying that. You already said that, ma'am.
You can proceed, ma'am. What is it that you'd like to tell me about your concerns regarding the September 3rd evidence viewing that's been previously scheduled?
My concerns is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court, other than sensationalism and exploitation, purpose would be for them to watch me look at the remaining bit of my evidence that has not been brutalized. Again, my main concern is it is for exploitation purposes, which has already been greatly applied to my case in many, many ways globally again. And I see on the motion to intervene for WFTVs, my question is, why is this an important criminal proceeding? I don't.
Ma'am, you're
why
giving
do they need to have
argument.
it monitored?
You should discuss why you think
I
it's
don't
not.
understand the reasons
The
why,
court
just
is
for
not
this
going to
one. I'm not asking for
answer.
all of my other hearings to be closed. Simply, this is my one and only. It is my right to have some kind of privacy regarding my case. Nonetheless, it is an active case, and it's my understanding that some information is not able to be publicized due to privacy.
Where's the
And
case law? This
it's
would be
not
your
their
time.
right
Where'd you
to
get the
have it
understanding?
operate, which is the whole point of why they want to be included in this one and only most important hearing that I would say that I have on the horizon. The press doesn't have a right to press themselves into everything in regards to my active criminal case. And I feel that from this, one meeting should be closed to the press so I can rightfully, lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the
But
internet.
that's not
I'm
in
trying to salvage
evidence.
whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing, and I'm asking for their admittance to be closed. This is an active, ongoing investigation case.
Anything else, ma'am?
No, Your Honor.
State, do you have any position on Ms. Boone's closure motion?
No, Your Honor.
All right. Ms. Fugate?
David, don't laugh. I wondered if it might have been a
I
sex
think
game.
Boone's argument really flips
try
the
that
question.
defense.
It's not why the media wants
They
to
took
be
their
there.
bondage too
What
far.
transpires in the courtrooms, even pretrial hearings, is public property, and there's a right to be there. I'm not going to go over the Lewis test because I know Your Honor knows it well, but it's a very strict standard, and it's the plaintiff's burden to meet. I haven't seen a case in Florida where a criminal case was closed on a defendant's privacy concerns. We're not talking about third-party privacy concerns or something that's not inherent in the proceeding. This is the evidence. And even with respect to the evidence and it being an active, still an active case, Florida law is clear that once discovery is provided to the defendant and accessible to the defendant, that becomes public record. That too becomes open to the public. So with respect to the first part of the analysis, I don't think the defendant has established that this hearing needs to be closed to protect her fair trial rights. Publicity isn't necessarily synonymous with prejudice. She has to show widespread, adverse, hostile publicity, and then specifically show why that publicity is going to be aggravated by access to the September 3rd hearing. The discovery in this case has been public. I'm not sure what specifically would be aggravated by access to the hearing. So I don't think she's met that first burden under Lewis. And importantly, the admissibility of evidence, Ms. Boone said she didn't think there was anything suppressible, but even if there was, courts often suppress evidence, but still allow access to the hearings and the evidence themselves. That's fairly routine. That alone, just the potential admissibility, that alone is not a sufficient reason under Lewis to close a hearing.
So true.
And as your honor is aware, there's plenty of alternatives under the second factor to protect the defendant's fair trial rights. Careful questioning and jury selection can protect against publicity. The courts of this circuit have had their fair share and are well familiar with high-profile cases, and they are well equipped to insulate and protect juries from even prejudicial publicity. And
That's
finally,
totally why she has fair.
any closure would have to be effective and broader than necessary. Again, I'm not sure why the hearing would need to be closed, but I think even Ms. Boone has indicated it would be ineffective with what's already out there. And that was a consideration under Lewis. If the information is out there, the discovery in this case has been public, there's no reason to close a hearing that's simply going to discuss things that have already been made public.
Right.
I think heightened public attention only increases the need for transparency. Closure of judicial proceedings is a drastic remedy.
Really fast, because I have two things to say and I don't want to talk over her, so you guys can hear her. I think Sheriff's shot herself in the foot several times, right, by saying globally. So not obviously it's not just in Florida, but her global fans are never going to be part of her jury pool. So why bring that up? But you're also showing that it's so saturated, it doesn't make sense to close the hearing, right? And then I don't know why she keeps going on about she's not prepared and she didn't. Like, he specifically said, I'm going to be looking at this case law. Even if he, like, girl, you were fighting for your life. Even if he didn't mail it to you on time, you looked up all that other stuff in all those motions that she put out. What was it, on the 9th? Or she put it, I think she put them out on the 5th and they were answered on the 9th, whatever it was. But she had all types of case law in there. Now, granted, it wasn't related to Florida, but she knew how to find those. And so when she keeps saying it's my right, and then she's like, oh, it's my understanding, girl, where's the case law? Nobody is here based on your understanding, because if that were the case, you'd be walking around free because it's your understanding that you can kill people and not be held accountable.
And I don't believe the plaintiff has met her burden in this case. Okay. Unless you have any other questions.
I do not.
Thank you, Your Honor.
All right. Any closing remarks from you, Ms. Boone?
Yes, Your Honor. First, I'm only asking for this one hearing, which is a very important hearing. I believe that the press is simply in it for ratings and publicity. My evidence is active, and I'm trying to salvage the little bit of anything that I have pertaining to my evidence that is not available online, which would be in that hearing. And I also heard she was speaking in regards to once discovery has been received, it is therefore a public record. I just received my discovery for the first time, and I'm still reviewing most.
You did,
not all of it,
but the defense
and
didn't.
I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information, I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly. It's publicity.
Well, would you like to enter that into evidence?
Incredibly enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received.
I don't think social media counts, and I haven't seen hostile.
I do not believe Australia. Just because
that's not your jury pool.
They would like to, again, in my opinion, for ratings and for publicity.
She says it like it's a bad thing.
That I believe, my understanding was that this could be held at the Orange County Sheriff's Department. The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court.
Yeah, then it's not a hearing if it's over there.
I would like to be able to properly prepare for this. Would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email.
Is that the third time she said that?
I'm sitting in front of you, yes, unhandcuffed, but I am unprepared for this rebuttal in regards for me to have privacy, expected privacy to a certain degree. And
not
law,
rebuttal.
To have this one
it was your motion.
And we also have an active
You're the
case
moving
that is
party.
ongoing, active evidence. And there's a solution for it to be held at the Orange County Sheriff's Department as well.
Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but the parties have reached an agreement to do this on our own. It seems like it's accomplished to both of our satisfaction. then I'll let the court know something.
Okay.
Oh, so it's really moot.
Ms. Fugate,
then.
anything else? All right. Under the Miami Herald versus Lewis case, ma'am, Ms. Boone, you had the burden of producing evidence and proving by greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your
Nico,
motion
oh
to
my
close
God.
the September 3rd viewing is denied. The court will follow up with a written order that you'll be hand delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon.
It was already posted to the website. He already had that bad boy typed out. He just had to make a few pertinent
Mr. J.
additions related to the actual
When
hearing.
you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
What was it
Yes.
specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th
You
when we were
sure
going to address
did.
it. I said that we would address it on the 14th. You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I
Okay.
was not aware of, I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have already
She
done so.
is a
That's why we had the hearing
liar.
now, because you asked for it orally. So you orally moved.
So this is a little bit tricky because there's a separate word and I can't think of it now. There's two words for orally, and the prosecution is the one who suggested it, right? But it's like oral something. If you guys remember, let me know. But and he explained that is to do it orally. And then that was on the 5th, and then again on the 9th. She said, what decision has been made? And he said, I'm looking at the case law. He specifically said Miami Herald v. Lewis. And he said he would send it to her, but girl, what were you doing all weekend? Like, what did she think was going to happen today? Somebody let me know. What did she think was going to happen today? Like, she was just going to say it's not fair. And I don't like, sometimes I'm just like, on the one hand, she's smart, but on the other hand, I just think she doesn't have common sense. Like, really, what is wrong with Miss
Or
Boone?
tenaciously moved to have that motion heard. And we set it up for today since we already had the hearing time carved out to address
He said all that.
you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said, I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for
Now,
the
I
case law.
remember,
said,
but to
"Absolutely, I
be
will get it to you."
fair,
Mr. J had advised
watched
he was
it about
familiar
5
with
times.
the case law. But regardless, it was
At
provided
least.
to all parties and mailed to you on the 9th.
Which I have yet to receive. I was not instructed by anyone in the court that was an oral motion.
Can't give you legal
requesting
advice.
Privacy. I thought it was just a comment that I could have on record.
Ma'am,
Not do anything further.
that's why we set the hearing, because it was
Yes.
something that you had asked for. And that's clear in the order that was provided to you on the 9th as well. It
By
says that we would have a
hand.
hearing today on the 14th.
And when did I receive this?
On the
That was
9th.
orally told you on the 9th. The letter itself was mailed to you on the 9th, but the order itself was read to you during the course of that hearing. Specifically on August 14th, 2024 at 1:30 p.m., a hearing will be held in courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB drug drive, which contains
Yeah, he
the
said a
state's digital evidence.
hearing, not a
The
time for
defendant's
Sarah to
August
make
7th letter to the
comments.
court, delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. That was all addressed with you, ma'am, on August 9 here in open court.
In the order I have yet to receive.
But it was read to you,
Yes,
ma'am. It was
DB.
read to you as to what we
Yes.
would be doing today, and that we would addressing.
It was
the
like,
issue regarding
I
the
couldn't
media's
see him,
participation.
but it was
That's
like
when
he
you
was
asked for the
holding
case law.
himself
That's
back,
how
and
we
then
give
at
it
the
to you.
end, he
Absolutely.
just was like,
It was all
"Mwah."
mailed to you on the 9th.
I don't want to spoil it for anybody who hasn't seen it, but oh my God, I loved it.
I'm not ever sure of what it is that I'm supposed to be doing with
Sugar Bear is
now,
nursing if
oral
you
and
hear
also
all
in
this.
writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me the day before yesterday, and or could have been.
You're not empty-handed. He printed you out a copy. Your hands
I'm
are
guessing
full
that your
and
verbalization
unshackled.
of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday, August 9th.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to.
Everyone knows. Everyone
reason
like
for Ms. Fugate to
who?
remain?
Nobody in this court.
Okay.
From the state.
All right. Ms. Boone, any
Is it
reason
your
why the
family?
counselor for the Orlando Sentinel and WFTV should remain? Okay. Thank you, ma'am. All right. In addition to what was set to be addressed today.
Her voice sounds like she
which
should
was
be a
the,
sweet person, right?
Ms. Boone's review of the USB jump drive, which contained the state's digital evidence. Ms. Boone's August 7th letter regarding her requests from
Yes.
the Orange County Jail.
Let the sunshine.
Mr. J, you made reference to a potential change in the September 3rd meeting. I want to hear about that, sir.
I believe we have 3
reached an
And
alternative
honestly,
solution to
I
evidence.
feel it's important for democracy
As
for
soon
the
as
courts
is
to be
accomplished to
open,
both parties' satisfaction, then I will.
so we
let the
know it's
parties
on the up and up.
Okay.
I know it's valuable.
Can you explain to me what the proposed plan is for the viewing?
There will be a time and place where the evidence
I'm gonna stop this for
will be
1
brought,
second.
and she will be given as much opportunity to
Yes,
experience
sir.
evidence viewing like a defense attorney as possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened.
So here's the thing. They already agreed. Oh, where'd you guys go? They already agreed, sidebar, if you will, sidebar, the state and Sarah Boone, that she was going to be able to go to the sheriff. So she actually could have just laid her motion aside or dismissed it, asked for a dismissal and not addressed it, because they're going to go outside of the court, which then it doesn't make it a hearing. The same as like when you do the plea negotiations, the media can't be there, which I feel like was coded language the last time the prosecutor was saying that. I don't think she's going for a plea. I think he was trying to give her an out, right? So that she could see it, because they don't want to have an appeal and they want to get things going. They don't want to move the date. So because all of this is now going to be at the sheriff's office and they're going to document it and submit it to the judge, the meeting is not going to be there. So I just don't understand why she went round and round and then was like super petty about it, like, which was just given to me, which I'm sitting here empty handed. Like, you're lying, you're making up stuff. He just gave you a copy of it. And to boot, the Sentinel piece was just filed that morning. So everybody got it that morning. You know what I mean? And you were told, y'all heard him, what the hearing was about. So I'm just like, Sarah, she's the only person I ever wanted to write to in a case, but I'm like, she's not gonna understand what I'm saying anyway. But I'm just like,
Then
I want her to have
brought back to
a
where it's stored, and then it will be brought back to the one county.
Okay.
let me go
Have you
back
had
so
a
you guys
conversation
hear
with
that.
Ms. Boone
I'm getting
prior to
heated. Wait.
for the viewing?
There will be a time and place where the evidence will be brought, the defendant will be brought, and she will be given as much opportunity.
Really?
Evidence viewing like
That's good to know, Jay.
possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened so that it can be photographed. Inspected as
No
a
one
copy
in
that's
Turkey
provided under
knows or
UPO
cares.
and criminal procedure rules. Then the evidence will be brought back to where
He's
it's
really
stored,
soft.
and it will be brought back to the one county.
Okay. Have you had a
Let me put
conversation
the
with Ms.
subtitles
Boone
on.
prior to today regarding this proposal?
Well, with Mr. Lane, who was indicated her position.
Okay. All right. Ma'am, I don't want to go into specifics of what you've had with your investigator, but has he relayed to you what Mr. J just advised the court of?
Yes, to a certain degree, it has not been fully explained because it is in the process of being
But
spelled out.
you know what he's talking about?
So yes, I do know that that is a solution to my request.
Okay. And did you understand what Mr.
My
J advised the
quest.
court of today regarding how that process for you viewing
You're not a dragon
the
slayer,
physical
man.
evidence would be?
If you could please do so again.
Sure. If you could explain it again for Ms. Boone, Mr. J.
When a defense attorney wants to do an evidence view, you typically go to where the evidence is stored and the law enforcement agency. He or she can bring an investigator, and an investigator is able to take photographs if so requested. We typically don't let the defense attorney manipulate the evidence him or herself. The CSI, who will be present as well, which is the crime scene investigator from the law enforcement agency, will be the person to manipulate the evidence on the cutting paper. And then
Sugar Bear's knocked out.
the opportunity to review, test, inspect each piece of evidence. So for instance, I'm not saying the evidence, but a piece of clothing, the front, the back, you have the CSI turning inside out, those sorts of things. And then documented by the investigator with photography. Between each piece of evidence, there's a new piece of cutting paper, butcher paper laid down so there's no contamination from DNA testing. And this is basically how the process goes on for physical evidence. If it gets opened, it'll get resealed by the CSI right there in front of all of us. And the CSI will reseal the tape, re-put his or her initials over it with the new date. So everybody.
Because she's special.
Why it was open, when it was open.
Thank you for that. If I may, is it closed or is it open to?
No. People that are not involved in the case will not be there.
And if I may,
So no media.
physically be there?
If it is stored in physical evidence, then it can be brought over. We're not going to.
Did she ask him about that damn phone again?
It can be photographed and physically examined, but in order for it to be turned on.
She must miss it.
Something called Faraday box, room where electronic signals not come in or out.
Do I need to write a motion for that?
For what? For your phone to be brought over and turned on?
If I can extract any type of information.
You need to hire.
Discussed at the last hearing, that would be up to you to hire a digital forensic examiner. And then we would make arrangements with that person that he or she could image the phone in the same manner that it was imaged live on.
Thank you.
Nico, sometimes it's 3 or 4 times.
Then,
I
ma'am,
think it's more
after
than
having
2.
Mr. J explain that alternative solution to the evidence viewing, is that something that you would like to participate in?
Absolutely.
Okay, so
Oh, is
then
the investigator
is
here?
it the
One thing?
parties'
Oh my God.
agreement to no longer have the evidence viewing here in open court on September 3?
He might need to up
That's
his
the state's
hourly.
position, but again, been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the board if you want to free up your hearing time now or wait.
Because Sarah's going to come up with some problem and they're going to
Okay.
be right back here.
Ms. Boone, are you in agreement
Looking
with
at
that
the
alternative
evidence.
solution?
At the Orange County Sheriff's Department?
Wherever the viewing is going to take place. I don't know that a specific location was identified, but
Hey,
yes, where it's going to
Cahoots,
take place.
thank you.
Okay, so then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing as set forth in the August 5 scheduling order and notice of hearing will remain of September 3. If that evidence viewing takes place at a law enforcement agency based on the protocol as identified by Mr. J, I'll just need a notice that's provided, signed by Ms. Boone, signed by the state, signed by Investigator Lane, as to when it took place and how long the viewing was. And if that's provided to me, we'll then cancel the September 3rd hearing.
Yes, sir, we'll do that, and we can even list physical items that were brought.
Oh, yeah, please do. Well, there should be a discovery
only-
list, right?
Question about that is we had sealed at the last hearing the witness list and the exhibit list.
I think all the property receipts and all those sorts of things are already in the public record.
Okay.
I think there's a vast difference between a list of evidence that's already in the public record versus having them look at it with television cameras.
Okay, all right, fine. Ma'am, are you
She's
amenable to that
confused.
additional procedure that after the evidence viewing takes place, you would sign a notice reflecting when and how long that evidence viewing was? Okay, and then once that's provided to the
Of
court, it can be
course.
filed and then the
Girl,
court
don't act
cancels
like you
September 3rd.
easy going.
Yes, ma'am.
That is done by the state?
The state will
Provide
prepare
the
it.
documents and bring them.
Yes, ma'am. The state will prepare it. All you need to do is just review it and sign it. Okay. All right, thank you, Mr. J. for,
Because if you prepare it,
providing
it
an
ain't
alternative
happening,
solution.
girl.
Um,
Yay, Mr. J. Save the day.
Ma'am, I wanted to go back and address
That was
your
her
request
molehill.
for
That's all
the freedom of
she's
movement
getting.
motion that we addressed last week and your desire to use a stun cuff. I understand that a representative from the Public Defender's Office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay. So if you wear a skirt, as explained to you
So hold
by
on,
Officer
hold
Barnett,
on. Oh my
the
God.
stun cuff is located on your calf.
She just likes to disagree. She is like an obstinate. So this is why the public, sorry, I know I'm loud. This is why the public defender is there, or the person from the public defender's office is there, because she's been probably harassing that woman saying she wants to wear a skirt. And the woman is like, you asked for a stun cuff. Are you sure you want your ankles out? And like I said, I don't think Sarah is all there. There's some French fries missing in her Happy Meal. So now the judge has to talk to her about it and clarify on the record that she was told if she wears skirts, her stun, I mean, did I say stun gun? Oh my God, that's a whole other situation. Her stun cuff will be visible to the jury, which kind of negates the whole point, right? Also, I wanted to say when the other attorney was up for the Sentinel, she said it's the plaintiff's burden, but I think what she meant was it's the moving parties version, because obviously Sarah is not the plaintiff, but she's the one who made the motion. Just I had to say that before I forget. It's the details for me.
Achilles area. It would be something that would be viewable by the jury.
Let me go
So
back.
you have, or
Achilles.
do you understand that if you
Of evidence that's already in the public record versus
be filed and then the court will cancel the September 3rd hearing? Ma'am, I wanted to go back and address your request for the freedom of movement motion that we addressed last week and your desire to use a stun cuff. I understand that a representative from the Public Defender's Office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay. So if you wear a skirt, as explained to you by Officer Barnett, the stun cuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So you have, or do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking me was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
As Mr. Barnett or Officer Barnett.
There I am. What in the hell is she talking about? Her understanding was that because he asked, that meant it could be moved. How did she come to that conclusion? Did any of y'all come to that conclusion? He's asking because he wants it on the record and he wants to clarify that you understand and there's not going to be. Imagine her as an employee. Oh my God. Oh my God. Okay, let me get back.
That explained at the last hearing how the stun cuff is affixed to a person. It is on the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire
On the
to
record.
wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need to consider.
I have.
If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it. And you're making a intelligent, knowing decision that they can see that and that you want to proceed with wearing a skirt.
Judge,
Your other option,
don't gas
if you do
her
not
up.
like either of those,
She's not making any
is
intelligent
the parties will
decisions.
remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today. And everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing statements, closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we have our trial case management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access to from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury, and those same restrictions would be placed on the state as well. I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
And by my hearings that we have spoken about the stun cuff, they are televised, correct?
To the best of my knowledge, the media has participated in the majority, if not all, of the hearings that this court has had with you.
Does the court broadcast live, or is it uploaded to the clerk of the court's website?
What is broadcasted live?
My hearings, in regards to all of them, basically.
You
but
think the court
recently
has
the
a
stun cuff,
network?
Is there anyone that would know that I'm already wearing it, if they could see it or not?
I can't speak to what everybody else knows.
Thank you.
So if I may, please, my options are pants, hiding the stun cuff, or a skirt with it being visible, or I am able to sit here at the counsel's table with leg chains on, and no one is able to move except for here at the counsel's table.
You'll certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
Okay, I just wanted to confirm that those were my options.
Correct.
And when do I need to make that decision?
You don't have to make that decision today. It's something that we can address at the trial case management in September. Ms. Click, I see you raising your hand.
Your Honor, I just wanted to let you, so this fully of what
If you could, before you get to it, and just announce yourself for the record, please. Yes, ma'am, go ahead.
Closed captions are not picking her up.
Stands right now, unless you have any donations size that happen at that size, you have 8 pairs of pants, 3 skirts, and 1 dress, and that is every, well, we do have shirts, but for
8 pairs of pants, 3 skirts that have been donated that would fit her.
So I just wanted that to be aware, so that Ms. Boone is making any sort of decision, in terms of what we have to be able to provide.
Okay, ma'am, did you have the opportunity to hear what Ms. Click said?
I did.
Do you have any questions for her?
If you
Of
could
course.
repeat, what it is that you all have available, the numbers?
8 pairs of pants, 3 skirts, 1 dress.
8 pants, 3 skirts, 1 dress.
Ma'am, do you have any other questions for Ms. Click regarding the clothing that the public defender is endeavoring to provide for you?
And if I do come to the decision, I can always have someone externally bring something.
Nico.
Absolutely, you can always have someone provide something in your personal property at the visitation center, which I described across the street from the center. That is not, the public defender office is in no way involved with that. So put it in your property, and the corrections with transport property.
Yes, ma'am, thank you.
All right, any other questions for her? All right, can Ms. Click be excused?
Yes, thank you.
Thank you, ma'am.
If someone says up, she says down. That's why I
The
think it
next
was
issue that I wanted
brilliant
to
that the
address
judge
was
got
the
her to agree to the stun
review
gun.
of the digital discovery.
But
Ma'am,
why fight
Mr.
for
Lane
it
was provided
and then
at our
insist
last
on
hearing
wearing
on
the
the 9th,
skirt?
the hard copies of the discovery, the USB jump drive, which contained the state's digital evidence,
And
and
then
digital transcripts of the depositions of
hold on,
Detectives Kelsey
sorry. Oh my
Hopsel
God, I
and
promise
Scott
I'll stop
Lowen.
interrupted so much. Why did she fight for the stun cuff, right? And then now she wants to wear a skirt, and so she'll be shackled, or she could have the stun gun, but she wouldn't be able to stand up and move around, which is what she also fought for. So it defeats the purpose. Nobody's even going to see you're in a skirt. Like, why are we having this conversation? She wants the judge to be like, oh, okay, well, we'll put it on your thigh. Who was that says she wants a thigh cuff? Oh my God, Nico. And then C. Morales. If I were her employer, I would look for every and anything to fire her, but she probably wouldn't keep the job for long due to alcoholism. Oh, good point. That is a great point, actually.
And he was to meet with you on Saturday at 9 o'clock. Did that meeting take place?
It did
Okay. What was provided to you, if anything, at that meeting?
what he and I did.
What was provided to you? What was given to you by Investigator Lane?
I want to know what was provided.
The digital evidence.
Let
we
me
went
find
over,
out.
And we're still reviewing the discovery, but I don't recall anything physically being handed to me.
Okay, all right. And when you say that you went over the digital evidence,
Didn't
are
he
you
bring
referring
the digital
to
evidence
the
with him?
USB drive with the 9 items that were identified in the state's exhibit list?
Yes, I do have that. We have not concluded going through that. We have other meetings.
But you have it.
tentatively scheduled.
That was his question.
And also in order to meet
Did
the
you
deadline
receive
for
it?
the objections of the 23rd of August.
How many of those 9 items were you able to review with Mr. Lane on Saturday?
Not more than one.
Oh,
Okay. Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seem to work.
Okay.
So why do you
did
need
not have
him
any
there
issues opening up any of those
to
files?
review them.
I personally myself did not open all of them.
Okay.
Oh my
All right.
God.
Okay.
So you don't even know. Okay, that's dumb. You knew you were coming to court. You would want to
Ma'am,
know if you had a problem. You
Mr.
need to
Lane
prove
also
it.
took possession of the hard copies. Have those been provided to you?
I would have
They were waiting
opened
at the
each
dorm for
one.
me upon my return of the last hearing.
Okay. And where are they currently?
They're located at my bunk area.
Okay. And what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
Yes.
2 boxes are at my bunk on the side in between other bunks.
Okay. All right. Are they in some type
Ooh.
of bag, or is it just the 2 boxes that are right there?
Just the 2 boxes.
Okay. All right.
So right at this moment, they are sitting back at her
Do
bunk,
you understand that?
unattended.
You've told me that you live in a
Anybody
female
could be
dormitory with limited
willy-nilly
privacy.
in that box,
You understand by keeping
In the
those boxes
boxes.
there may be a risk as to other persons looking at them.
like right now.
I don't have any other choice.
Okay, but do you understand that that risk exists?
Of course.
Okay. Do you understand that there's a risk that those items could disappear?
I understand.
Okay. All right.
They could
Did you understand that it's your request and choice to keep those documents in your possession?
I do, and I'm also requesting in my letter to the captain and to the major to also be able to store all of the USB
the
drives and the hard
captain
drive
and the
in my locked
major?
drawer, also for an extra security measure.
What about the major
All right.
general?
I see that we'd have Investigator Lane here. Sir, if you can come up, Madam Clerk's going to go ahead and swear you in.
Yes. I think you're right, DB. I do think.
Sir, good
yeah.
afternoon. Can you state your name for the record and your affiliation with Prison Break Investigations?
Billy Lane, owner and chief investigator of Prison Break Investigations.
All right. Thank you, sir. I did see that your notice that you provided regarding
And then why does she care about the recording? I think she does want it to be seen, right? Because she's like, is the court going live? You need to be worried about the jury, the 12 people that are deciding your fate. Who cares what is going on with the cameras? Like, I don't understand, Sarah.
the distribution or providing the discovery. You provided the hard copies and the USB with the digital and the USB with the
Agreed, Jane.
depositions of the 2 detectives.
That's correct.
Okay. All right, sir. And
Oh, that's
when
not
you
fair,
met with Ms.
Sarah.
Boone on Saturday, again, I don't
Is there
want to go into
a
any
stun
specifics, but
gun
were there any
among-
issues
stun cuff
accessing any
among-
of those USB drives or any of the files?
Not at the progression in which we made through the files.
Okay.
As I will happy to let you know.
All right, very good. But as of right now, there's been no issues as to access from what you've reviewed. Okay, all right. State, do you have any questions for Mr. Lane? Ma'am, do you have any additional questions for Mr. Lane?
In regards to the drives?
Correct, based on what was teed up for
What
hearing
else
today,
would
which
it be in
was
regards to?
addressing your review of the USB jump drive, which contains the state's digital evidence.
Mr. Lane, are you able to briefly meet with me downstairs after this concludes?
I'm not sure if that's permissible with the policies and procedures. If not, I'm still trying to do a meeting with you.
He's
Any other
not sure
questions
it's
for him, ma'am?
permissible, he said.
Your Honor?
All right, can he be released?
Yes.
All right, state.
Free, free.
Thanks, sir. Appreciate you.
Free, set him free. Free, free. Set him free. Poor
Okay.
Mr. Lane. I
The
feel
next,
bad for
ma'am,
him.
is your letter from August 7th to Captain DiGiovanni, which is the court has had the
I
opportunity
was
to
thinking
read.
this
I
too.
believe that we have a representative from the Orange County Jail who's appearing virtually. If
Maybe
you
it's
could please
close to
unmute
short,
yourself and
so she
turn on your
wants it. Maybe
camera,
she wants like a
whoever
golf
it is that may be
shirt.
appearing from the Orange County Jail. I have a Administrative Sergeant De Jesus on the link.
Jesus, come through.
Good afternoon, Judge. This is Captain Gina DiGiovanni with Orange County Corrections. I'm the captain of the Female
Sorry.
Detention Center.
Sorry.
And yes, I have Administrative Sergeant Stephanie DeJesus with me.
All right, very good.
I also want to make it clear that I have Orange County Corrections Department Legal Counsel Scott Chevenel on the phone with me.
Okay, very good. If all of you can, if
Came
the
through
Captain
packing.
DiGiovanni and Sergeant De Jesus, if you could
Attorney
please,
locked and
let me
loaded.
see you, Captain. If Sergeant De Jesus can come into frame, we'll have
Oh,
Madam Clerk
okay.
swear you in.
Bottom
If you
right,
both
let
can
me
raise
do
your
it.
right hands.
Yes, ma'am.
I do.
All right. Could you both state your names for the record for me again?
Administrative Sergeant Stephanie DeJesus.
Captain Gina DiGiovanni, Security Operations, Female Detention Center, Phoenix Facility, Genesis Facility.
And can I get appearances for legal counsel for the Department of Corrections, please?
Scott Chevenel, County Attorney's Office, representing the Department of Corrections.
Okay. All right. Very good. Captain, have you had the opportunity to review Ms. Boone's August 7th letter
Nico, bottom
regarding
right
some
of
of the
this
requests
screen?
that she
Yeah,
has
I don't
in
even know
this
if you can
case?
see my
Yes, and if it's okay with you,
over
Judge,
here.
I'd like
or
to
where?
address each request
Or
one by
down
one. Do
here?
you have a copy of the letter?
I do. And
Or is it
we
reversed for
we
you?
can proceed with the
Over here.
7 different items that
I gotta
she
see it.
has requested. So if you want,
Actually, so with number one, the request to have her review time extended, I can make the extension in the following fashion. We'd
Yeah,
still have to
she's an
collect
HR
the
nightmare
laptop
again.
at
Like, oh my
4
god.
p.m. This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10
Thank you. I
p.m.
was like, I don't know the right.
and
'cause, like,
Friday night and
my
Saturday
image
night
isn't
from
first.
8
I wasn't
p.m.
sure.
to 11 p.m.
Anyway, thank you.
That
I'll keep
is
an eye.
more than the requested time that she has asked for additional viewing.
ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m. and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes,
All right. Do you have any questions regarding that extension?
I do not,
Okay. Is that acceptable?
very much.
All right. Moving to the next issue, Captain, the USB drive security.
Number two, USB drives. It's a matter of security. The metal tips, the drive
Control
itself
freak.
can be fashioned into something other than what it's originally intended for. These items are secured in a secure control room and inventoried by our supervisors on every single shift. They're also inventoried and acknowledged being in good working order and repair by my DSTs, the escorting officer, and my supervisors. So there's at this point, unless directed by legal counsel or consultation with legal counsel, I believe that these drives are secure and managed. This, by the way, is the same way it's managed by other facility captains, that you get a viewing period and then everything gets secured and inventoried.
Yes. Which is safer
Ma'am, do you
than
have
in
any
your little
questions with
raggedy
regard
drawer with a
to
lock.
the USB drive request in your letter and the position of corrections regarding it being a matter of security and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why, other than the fact that the assumption could be made that it could be made into something other than a USB drive.
Yeah,
I'm
it
trying
has
to
metal.
avoid any further leaks of information that could possibly be suppressed.
That
and
is
utilized in
not
my case.
how you're going to
So I
do
didn't
it.
know if I could have my hard copies. I'm unclear. Other
First
than
of
those
all, what
reasons
leak?
why I cannot have those as well.
To the extent you're able to answer that
Question
question,
on that.
Captain.
I would just chip in that, obviously there's safety issues and you can definitely distinguish between, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem, it sounds like to me, is anything that could be a safety hazard is an issue for us.
So,
So
ma'am,
you
do you
don't
have
have
any other
to
questions
understand
regarding
it.
the corrections department
You
position
don't have
with
to
regard to
understand
USB
why,
drives?
but you understand what she said.
What was the outcome?
You can have
It
them.
sounds like they're, unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of storing, inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
You didn't
And
miss
that's due to
anything,
metal?
Judge.
That's due to the reasons that were already identified. The matter
On
of
the record.
security regarding the drive being fashioned in a way that may affect security,
You waste
and
so
it
much
continues to
time.
ensure
What
that those
difference
drives are
does
secure,
it make?
controlled,
They said
inventoried, and
no.
in good working order. Do you have any questions?
Could you please provide the last name of Scott, the legal counselor, please?
I'll spell that, Judge. Shevennell.
Shevennell.
One more time, please.
Shevennell.
Thank you.
With regard to the third request, is to a
Gamble?
classroom, Captain DiGiovanni?
So that classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use of a classroom. What I can offer is if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her and she can review and
Remember in
conduct
her interrogation,
case review.
she can't be in a, well, she
will
says
still
she
have
can.
access to a shower. She will still have access to open day room time.
She had
She
a
will still
panic
have
attack,
access
remember?
to
She said that.
phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
That's a shoe, right? Secure housing. That's like
Yes,
in the
ma'am.
hole. Secure
Captain, is
housing
this
unit.
the Lima dorm?
K dorm.
Kilo. So my only options are being moved to the maximum security
Ah,
dorm
okay.
or
Heaven no. I'm gonna have to look him up.
K dorm is no longer maximum security. It's a multi-purpose area with inmates of varying needs
Definitely.
being secured and housed there.
My toddler doesn't do that.
so
Don't
it is
jinx
not
me,
the
DB.
maximum dorm any longer.
That's correct.
And I'm unable to utilize the classroom for an hour or two per day while it's dark.
He
the
already
entire.
said no.
That's correct.
And if I may ask, other than it being accessed on a rare occasion of the two
She's
classes
taking
that
advantage
do
because the other
participate in that
inmates don't
classroom,
get to question the captain.
why
you
is
know?
it that I'm unable to sit and be viewed by the officers at all times
Follow
in my
the
dorm comfortably
rules.
to be able to utilize the phones on a regular basis, the day room on a regular basis, to be able to go outside to recreation, to have
She was
just for fresh air?
copies and USB drive.
How is
She said
that?
somebody stole it.
I'm not understanding
I gave him the
specifically
feedback.
why the reason
Oh,
is
so
it
you're
has to be
actually
so extreme
speaking
from going to
futuristically.
being locked behind a door 24 hours a day to not being able to just utilize the classroom for an hour or two per day.
Ma'am, you will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours.
Yes, Trent. Oh my God.
And instead of having to move
And
items
an
from
office.
a
Don't
housing
forget.
area into
And
a classroom where
a word
the
program.
officer may have line of sight, I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security of that classroom while something may potentially occur in the housing unit.
Something might pop off. Pop.
So as a matter of security to the rest of the inmates in the housing unit that you are currently assigned, my staff and the facility, I can make the.
I think that's fair. What do you guys think? Now, obviously, I've never been an inmate, but I think the inmates would peep, what is that, dry land through muddy water, and they would know that was a good time to act up while they were watching her, or the jail would have to staff another body. And who's paying for that? To just watch her. Like, she only thinks about in her little bubble and not like if this, then that, which is why she's in the situation she's in. Like, long game it. Play chess, not checkers, ma'am.
Accommodation where I could put you in a single person cell where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
I've been in a situation where I have been behind the closed doors also when I was made PC, when I first got to Orange County Corrections Department. And if it's anything like that, I do not ever want to have that experience again. And to be honest with you, forgive me, Captain, but I do not believe that it would be this simplified. And nonetheless, I'm behind a closed door for 24 hours.
Okay.
Is there anything that I can do?
You're in jail. You're always behind
research
a
or further
closed,
explanation in order
locked
for me
door.
to try to still be able to utilize my dorm, which is general population dorm, where I do have friends and I do have
Right?
some type of comfort
Is it
there,
Rock V? Hello.
in order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours? Captain?
Judge, I'm going to object to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this kind of this broad general question about alternatives.
The objection is sustained.
In regards to number 4, earphones or headphones, I would need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command for guidance in that request. With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits.
And you never.
So again, I need to refer to legal counsel with legal counsel and my chain of command to get guidance on that. Regarding number 6, a word program. We've not had a pro se inmate, again, myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we can make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make all necessary calls. Hold on, I'm turning the page. For my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly, I believe that's diminishes. I don't know what the other word is here. If not all of my opportunities to properly prepare. The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications.
Right.
Number 8, discovery hard copies. It seems that Ms. Boone already has access to her hard copies. The concern I have to do now is do some research with legal and my chain of command, because that quantity of paper can potentially become a fire hazard, and we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards, but the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the 2 cases of paper discovery.
All right. Ma'am, do you have any questions
100%.
regarding
100%.
Captain Giovanni's
Because I don't know if that was you who
and
said it. Who
Orange County
said
Jail's
it?
position with regard
She would be
to
harassing
the earphones,
witnesses. She'd be
headphones,
calling
internet
Brian,
usage,
and it would
word
be recorded.
processor,
begging for hot food and
telephone,
alimony.
and the concern regarding the hard copies and it being a fire hazard.
I do, and I was also including number 3, the classroom utilization. I just want to make it clear and in open court that I want to have the understanding with everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is or my option to be moved, but I have the ability to make that decision.
Yes, those are your options.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security
I would
and
take it.
potentially Miss Boone.
You have all day to just work on your case. You are fighting for your life.
Okay.
Get behind the locked door.
Am I able to proceed?
You can.
You don't need headphones,
So for
any
my
of that.
understanding right now, you need to speak to your legal counselor in regards to the headphones, the internet, the Word program,
No.
and the discovery hard copies, which I already have. Is that
Counsel
correct?
is right there. He didn't pipe in
And
and say
telephone
it
access.
was okay.
Oh,
You want unfettered telephone access, if I read your letter correctly.
reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week where I save all of my calls for a particular day. I'm always up for solutions, just whatever it is that I can do in order to progress properly and expeditiously. I'm trying to do so by having this where I am confused why this was not all solidified prior to the implementation of the laptop. So I'm
shade.
I'm waiting for
So
whatever it is that I can
nasty.
do to
She
fully
just
access.
was like,
and
why were you
become a
guys didn't
pro
take
se
care of this
defendant and inmate.
before?
Do you know when, how long the deadline might be for the open-ended items that I would be waiting for?
Nothing's open.
No, just a scotch. I mean, I'll chip in with the legal piece. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above, what our typical stance is for pro se inmates. And all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
Is that a position, Counselor, that you're taking today? Because Captain DiGiovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's got to talk to her folks as far as the security end of it, because a lot of those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is,
No.
legally she's allowed access to the court and all these other things that she wants. And really, and I'll tell you what the case law says. The case law says if she's pro se, she's entitled to get, a paper, a pencil, and some stamps and some envelopes and those types of things. The idea that she wants unfettered access with the phone and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, she's gone through, I think, 8 attorneys in this case, and she has several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Ma'am, do you have any other argument with regard to these
did I miss
requests
the lady
as
laughing?
to the
I hope she laughed
headphones,
at that part.
internet,
Oh my
word
God.
processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County
Balls
Corrections Department?
of a burglar.
I'm not going to answer that
Not
question.
being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other
You're
pro
asking
se
for more
inmates,
than
what
what-
is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone.
Check your
And I'm pretty
emotion.
sure that they were not able to complete their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Sarah's about to blow. He doesn't have to answer that. He's not a witness. He's there as counsel.
Counselor, if you
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney for
Right.
one of the participants, sir. If you're under no obligation to answer that question. You are just providing your legal position with regard
Gabby,
to the
Jane, you
Ms.
guys are on the
Boone's
same
demands
page. Yes.
and requests.
They're simply requests. And I'm not sure who it might be that could answer my
wait.
question, please, in regards to what prior or present other.
To these requests as to the headphones, internet, word processor, or telephone.
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my pro se attorney's prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that
Not
question.
being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Silence, crickets.
Counselor, if you.
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney for
Right.
one of the participants, sir. If you don't, you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands and requests.
They're simply requests. And I'm not sure who it might be that could answer my question, please, in regards to what prior or present other pro se defendants and inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates that have come through, that are there right now, that have come through the jail, and they get standard treatment. And she wants a lot of things that are over and above that. For instance, again, unfettered phone calls. She wants to keep things in her cell that she can't normally keep, that they wouldn't allow folks to keep. So there's a lot of issues. I mean, that's a wide open question. But, can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that, we could probably find plenty of examples, if need be, as to what people have received in the past. And it's nothing close to what she's requiring or requesting today.
Okay. Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request as to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously on the record. With regard to your request to hold the USB drives in your own personal lockup, for the reasons identified by counsel Chevenel, it's a matter of security, and the protocol which secures, controls, inventories, and ensures in good order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain DiGiovanni on the record. However, there is an alternative housing offer that can be provided for you.
Hi.
With regard to your request for headphones, that has been rejected and denied by virtue of legal counsel's argument and what is being provided to you. With regard to the internet, word processor, and telephone, again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of an investigator, and JAC provided you $10,000 and $1,000 for travel for your investigator. To the extent, as requested for the purposes of internet, for locating witnesses and experts, you have a personal private investigator that can utilize. He can do that for you. I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone, based on arguments of counsel for Orange County, I'm unable to accommodate those requests. Jail is unable to accommodate those requests. Those requests will not be provided. With regard to the hard copies, that's going to have to be a matter. If it needs to be addressed, it can be readdressed with regard to the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured housing in the K dormitory?
Yeah, it's basically the Florida Model Jail Standard 7.12. The officer in charge or designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument, and authorized reading materials in reasonable quantities as approved by the officer in charge of designate. Personal items will be kept in an orderly manner. Fire potential is reduced by limiting the amount of personal property in the cells. So it is the sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in Miss Boone's letter, if you give me one moment. In number 8, discovery hard copies, she writes the following: as I am presently, I can keep these in the permitted property bag discreetly located at my bunk. I will purge the documents I have now and keep only new discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. I am willing to
Who is that convenient
see
for?
what she's going to purge and send to property.
Ferreting back and forth your
But
docs.
at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have here, along with the
listening,
almost 100 or so assigned staff, civilian and certified.
or is she writing down why she can't live with the rules?
I will also say that pro se inmates in the past have been afforded a second fire retardant property bag, and I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above that, we may have to find an accommodation. And based on the willingness of the letter that Ms. Boone has written, she articulates clearly that she's willing to purge and send to property any paper that's over and above.
Right.
Do you have any questions? No, go ahead.
And I
I'm
can
sorry.
have that second property bag upon her return this evening.
Ma'am, do you understand?
She doesn't even have it in the property bag now. She's
second
got the
fire
2
retardant bag that
boxes
can be provided to you regarding the hard copies
by
of
her
discovery.
bunk.
I do, and it was already
She's
provided
just a
to me,
liar.
but the boxes unfortunately do not fit in the bag where I did
Right.
attempt numerous times and even had others try to help me.
So you have to purge.
I also did not know that they were fire retardant bags. I have the one already
With matches in it.
and I'm in the process of trying to figure out what needs to be purged. I also have my second family law case that I'm trying to be able to obtain those copies at my bunk as well, because of the difficulties of receiving
Family
and
law.
delivering anything to the property department, which is why I came up with the solution of me trying to purge what I can specifically to be specifically removed from the jail completely by a friend who can come and pick
Okay,
that up.
hold on. So if you guys look at the docket too, the family law files have been locked. But before they were locked, I remember reading, yes, sir, that judge was like, we're going to decide this after your murder trial is resolved. So when she's saying she needs that at her desk, she's just at her bunk. She's just like a bold-faced liar. You don't need anything with the family law case until this case is resolved as per the judge.
I was just waiting for this hearing to happen so I can figure out when to tell her to come to do so.
So is that accommodation acceptable?
It is. I returned the second fire retardant bag, property bag, because I didn't want to have anything extra on top of my extra already. And it is not able to be used for anything that I can put in there, where I already have everything in the boxes in the one bag already being occupied.
You can't have the
satisfied
boxes.
Then with regard to the treatment, for lack of a better word, of the hard copies?
What do you mean by that?
Sure. Are you, the procedure for having them stored and where they're kept is identified today? Is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
Oh, I thought she said they had to
Judge,
go in
may
those
I
bags.
say something here?
Sure.
Okay, and thank you for allowing me the interruption. The cardboard boxes are not authorized by the fire marshal.
Okay, that's what I thought I heard.
The fire retardant bags are.
So it has to go in the 2 bags.
The documents are going to have to come out of the cardboard box and into the fire retardant bags.
That's what I heard. Okay.
Ms. Boone?
I would have to figure that out for the voluminous amount of paperwork that are.
Who
contained in those
cares?
boxes.
It's got to happen.
And
Nobody
there's
cares.
no way to organize or separate. So
Okay,
it would
well.
just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of
There's no
organizational
folders.
structure of those 2 fire retardant bags with my.
There's just 2
hard copy
boxes of
discovery
loose
enclosed
paper.
in those. If I could please do so.
Who believes that?
Mr. Chivinell,
Captain Giovanni, is there any way we can give her an additional bag or so, and she can switch it in and out of property or whatever it may be? Can we provide her an additional bag that may help her to separate her documents?
I could provide the
Agree.
3rd fire retardant bag, but
That's it.
it's the encroachment into another inmate's area.
Right.
It's a limited space. But the cardboard box can't remain.
That's what I
And Judge,
heard.
if you recall my request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail for this very.
I recall it.
And I understand that.
Nobody could wait till
and
you
Ms.
got back
Boone
from
has
vacation.
continued to request the paper copies. And that's
Like a
why
dog
everything
with a
was
bone.
digitized, so that you would have that access to it. Everything has been digitized. But she has continued to request for those, and we're trying to make that accommodation for her as well.
They're bending over
Yes.
backwards for her.
Scott, if everything's digitized, why do we have to get the paper?
Thank you.
That's up to her if she wants paper or not. That's fine.
It was never my decision to have anything digitized.
Yeah, it's
in the
not
first
up to
place, and
you.
Nonetheless, it's being put on a laptop that is not even fully accessible because some of the programs do not work, which I have not had the time yet to continue to go through everything that are on the USB drives. And that being not my
Is this
decision,
you
nonetheless,
looking
most
for
important to me,
solutions?
they are limited and restricted to particular time periods. When those laptop times are closed for the day, I can therefore pick up the hard copy discovery, be it in a fire retardant bag. or in a
Lawyer already
cardboard
said you
box
could
or
have
whatever
them
else it is that I'm able to keep
in
them,
the
then
fire
I are.
retardant bags.
I have that as plan B when plan A is closed.
Judge, if I might be able to offer a resolution here.
Okay.
Was the discovery that Miss Boone received, was it just a stack of papers in the box, or was there any type of manila envelope or filing separation system?
I haven't looked at them. I haven't copied them. They were opened in court back in, I think, June 28th, when we had the hearing where the court found that Ms. Boone had forfeited her right to court-appointed counsel and alternatively have waived that right by virtue of her conduct. I believe the box was open at that time, and
He was like,
there
let's
may be
get that
manila
on the
folders
record again.
for some of the items, but I can't speak to all of it.
Are
I
those
haven't reviewed it.
folders
I'm not able to
there?
review it.
Miss Boone?
Would Miss Boone be able to indicate whether the paper is free-flowing paper, or was it bound in some way?
Ms. Cashman had represented that all staples had been removed and all paper clips had been removed.
Oh.
Ms. Boone,
It is a mass amount of paper.
are there dividers? Are there manila folders?
Right. That's the
There, I
question.
believe, are 2 manila envelopes that have contents inside.
And everything else is just free paper?
As far as my understanding is, yes. I've not been able to fully dive into the boxes quite yet.
Did you take the lid off?
Information for this.
All you have to do is take the lid off and look.
Explore once I return back to the dorm.
Oh my God.
I can provide some manila folders without any type of clasp or string in order to get the cardboard boxes out of the building.
Most urgently.
I understand. And that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified pen and papers I am able to have.
3 bags, ma'am.
My question is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to
Yes.
the
he
amount of
did.
paper,
That's fine.
is that
He shut her off.
the definition that you provided, is that for the enclosed housing area, or is this also for general population?
Ma'am, I'm responsible for, based on the Florida model jail standards, to reduce the amount of paper clutter.
Thank you. That's my mom's name, by
in
the way. She's supposed to
all
do
living
that's my mom's
spaces.
name.
It's not
I
specific to
appreciate
just your housing unit.
Thank you.
Captain Giovanni, does that now, can she switch out and get things out of the property within reason if there's additional documents in her property?
Yes.
Through the request form, if she, we're going to authorize the second fire retardant bag. We're going to offer some manila envelopes without a metal clasp or string so that she could get everything into the fire retardant bags. And then we're going to remove the cardboard boxes, which are what becomes
I
or
think this
is
is
the
too
fire
much
risk
because there's going to be an issue.
because it is not
She's gonna be
authorized or
complaining.
recognized as a
Like they can't
fire
just come
retardant
and go
item
with
based
her
on
stuff.
the fire marshal.
Like she's gonna want.
The only thing that they consider
She's
fire
got a
retardant
set of rules.
is the bag. And again, I will provide that. And then anything in excess, she could send to the property room. Well, and then upon her need for it, she could write a request to the property room, and the
Right.
property room will bring it over.
You get what you get.
But she'll have to swap it out.
Beggars cannot be choosers.
I'm amenable, I'm amenable to her keeping her documentation. I'm not looking to take anything away from her, but it has to be in
Compliance
accordance with,
the rules.
fire marshal and policy.
I understand. And I would be happy to comply with the extra bag and the manila envelopes for separators in regards to that.
So, ma'am, if the jail was to provide you those manila folders for the hard
As
copies and a
dividers,
third
right?
fire retardant bag, is that acceptable?
If it's
It
not
is
tough
if I
goodies.
do conclude that I need anything additional in order for them to be able to be held together in regards to some
No,
type of
no
rubber band or
staples,
some
no clips.
kind-
Who rubber
elastic,
bands
something to
paper?
be able to bind the paperwork together. Is that a possibility?
No.
I didn't hear the question.
You may have to speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed, to have a type of rubber band or some kind of elastic in order to bind?
No,
And I know, Captain, that you are aware the courtroom is not in regards to the property bags that you all do supply. There's no rigidity to them whatsoever. It's just a floppy bag. So
Who
when
cares?
you pick that up, everything goes in the middle. So there's no type of there's no way of actually being able to make sure that one pile stays in the one pile and so on and so forth. Do you have any
You just wanted to
suggestions
get that
other
on the
than manila
record.
folders
No.
that I might be able to utilize in order
No.
to keep those together?
Nope.
the purpose of the manila envelopes is that you would put the paper in the manila envelope.
Oh,
that
and not as
manila
dividers.
envelope
Okay.
keep the paper in order.
Okay, so they're envelopes, not folders.
Correct.
Thank you.
Ma'am, is that acceptable to
I'm
you? And
glad
is there
you
anything
can
else we need to
choose,
address
Ray.
with regard to the hard copies?
Not in regards to the hard copies, no.
Okay, all right. Is there anything else, ma'am, that we need to address today?
Same, DB.
Yes, please, if I may conclude with the remaining amount of questions.
They
I
be
have
looking for me
regards
in
to
the
my
daytime with a
requests.
flashlight.
Is it Mr. Shebamel?
Yes.
Could you please provide me with the
didn't want to
protocol or policy that you will have a guideline for me to follow, please, in regards to what previous pro se inmates may have
Well,
had
it's not
access to and be able to utilize?
day
Do you
camp
have
where you
anything
get
in
an
writing as a hard
orientation.
copy?
We'll have to check on that. Are you making a public records request?
I'm sorry?
Are you making a public records request?
I'm
We don't
unclear of your question. I was just asking if Orange County Corrections Department had any type of guideline that you are accusing me of going above and beyond, other than the pen and paper. So I didn't know if you had a policy or process.
Nasty.
In,
He didn't accuse you.
if you
He
have a pro
stated
se
the fact.
packet, like JAC has a pro se packet. Does Orange County provide something like that?
You have to ask the jail that question. I don't know. I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as to what the law is, but I'll certainly advise the jail as to what the legal standard is.
I love him.
Yes.
I wish
Captain,
I
I
could
would
see him.
be
I'm not going to
responding
provide
to
it
you in
to you.
regards to that or following up with you or Sergeant DeJesus.
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop and the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Shebamel, you
She's wasted so
repeated
much
that I have access
time
to the
on these,
court.
like,
Could you please define to me
nebulous
what
things.
your access to the court is for me?
Yeah, I'm going to object. I'm not a witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know
Yeah.
I've entertained a few, but I'm really not
Sustained.
required to answer any.
Ma'am, he's not in a position to answer those questions.
Could you please answer who might be able to? Because I
Oh
am
my
in desperate
God.
need to view the case docket, which requires internet, and I am still waiting for any documents that you have mailed to me.
Can't someone
I'm
in your
unprepared.
family or
It
your
seems every single
fans?
time now sitting here at the counselor's table with not the same information and opportunity and advantage as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those more expeditiously and in a
Nope.
timely fashion so I can be prepared in order to properly defend myself in apparently
Don't fuck
more than
around and
one
find out with 8 lawyers.
way for every time that I'm here in the courtroom and something new is presented to me as a surprise. So I'm just trying to
Surprise!
Items
We
will
know
continue
she
to be
hasn't
mailed
lied
with
to
you, mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify. my
Yes,
understanding
they
is that
are. They have to
receive
be.
anything is through United States Postal Service.
I'm not going to answer that question because that would be potentially
Baby,
providing you
yes,
legal
you
advice.
did. Don't give
But
her
what I
my
can tell
number.
you is that items will still continue to be mailed to you as required by
And
those
don't
rules.
give her
If I may please just make
free
sure
calls.
that everyone is aware that I cannot be properly prepared, as you can see now and prior. I just want to make sure that everyone is aware and understands.
Thank you,
Ma'am, for the
dog
reasons that we've
mom.
discussed
I'm a
previously,
dog mom too.
I
I'm
understand
cute.
that. You're entitled to that opinion as to your pro se representation of
He's
yourself.
quiet and I'm loud.
Anything
I'm
else that we need to
sorry.
address today, ma'am?
Yes, I have a motion that I would like to submit, please.
Okay. Is there anything
Another
else that
motion?
the jail needs to
Lord.
participate in with regard to this hearing?
Captain, would I be following up with you, or who would I be speaking to when I return to the dorm?
About what?
In regards to what?
I'm wondering in regards to the guideline and when and how the
She
discovery hard copies.
doesn't have it.
Will the property bags be waiting for me when I return?
I will take care of that with my supervisors that are on shift.
Yes.
We will need the cardboard box so that we can dispose of
Post
that
haste.
properly.
We need it.
Yes, ma'am. And if I
'Cause
may,
that could also be a
do
weapon.
you know why it was not approved prior when a supervisor was the one who delivered it to me?
Because she was on vacation and you were
I
being.
had no information about even the amount of hard copies. I didn't even know that that came into the jail because my conversation has always been that everything would be digitized and that we would have no hard copies so I could be in compliance with the Florida Model Jail Standards, Orange County Fire Marshal, and our policy and procedures regarding excess amount of paper.
Yes, ma'am. I understand. Thank you very much for your time.
Captain,
And Sergeant
don't play
DeJesus
that.
and Mr. Chebamel.
Okay, are they free to leave?
Yes, thank you.
All right. Thank you all very much. Ma'am, you made reference to another motion or something else that you had.
Yes, I have a motion.
Okay, if you can hand it to the deputy behind you. Actually, deputy, can you hand it to the state? State, you can take a look at it and then I will.
Totally. Is it Blake
Thank you, sir. Ma'am, give me a moment to take a look at this.
815? Or is it BL 815? Is that an area code? What's 815? Let me see. Illinois. Are you in Illinois? Covers most of the northern part of the state, excluding the Chicago metro area and the Quad Cities. Is that you? Is that 815? Are you repping? Super nasty. Imagine her drunk and demanding things at a bar. Imagine. I mean, the audacity that she has, she should be running like a large company. Do you know what I mean? Because she has balls of a burglar. No, like she can't humble herself.
Court has been provided a motion for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of the defense.
Could she be any more above the top? Girl,
State-
hi, Lumiere.
I don't think we can have a
We
hearing on
might.
this without JACS.
State takes no position. We don't have anything to do with this.
Okay. Ma'am, I can't have a hearing on this today.
She wants
I'll have to
to.
coordinate a hearing with regard with JACS to have this heard because this is something that involves them. And they haven't even had the opportunity to review it yet.
And they are copied on that as well.
I do see that, but you're hand filing it with me right now.
So they haven't
So
seen
the
it,
court
ma'am.
will file this in the court file and we'll coordinate a hearing as soon as practical with regard to this motion, and it'll be heard before the end of this week. Anything else, ma'am?
Exactly, Gabby.
Just to confirm,
Well,
please,
David,
for
she's not
the
gracious.
deadline for my responsibility to meet would be the August 23rd for the objections to the state's USB.
Oh, thank you,
As
Gabby.
identified in the court's order, that is the deadline. The only other deadline, ma'am, is the September 3rd deadline for the viewing of the state's physical evidence, which
Yes,
sounds like that's
yeah.
something that may take place prior to that deadline. As you may recall, you will have 14 days after that evidence viewing to tender any of your objections in writing to the court, 14 days thereafter, and that will be extended for good cause shown. Anything else, state?
Nothing, state.
Ma'am, anything else?
No, Your Honor.
All right, we'll return Ms. Boone back to the custody of the Orange County Jail, and we'll coordinate the hearing appropriately. Thank you all very much.
Deuces, Sarah.
Forgive me. In order possibly for a solution for me to know about the hearing, especially for the one regarding the JAC, is it possible for you please to relay it to Mr. Lane and he can tell me sooner than the mail?
Mr.
I can
Lane
certainly do that.
should check the court
I would have
docket
some
on a regular
opportunity
basis, like the rest of us.
quicker than waiting for the mail.
I can certainly advise him of that, or my office can. Sure.
But you know
Okay,
it's
I understand.
coming.
All right, just so for recap purposes,
prepare.
with regard to the motions to intervene as first addressed this afternoon, the court orders that the defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Publishing Co. versus Lewis, 426 Southern 2nd, 1 at pinpoint 8 by the Florida Supreme Court 1982. As such, the defendant's requested closure of the state's physical evidence viewing with the state and defendant set for September 3, 2024 at 9 a.m. is denied. With regard to the other items that were discussed today, defendant and state agreed to an alternative arrangement as placed on the record on August 14, 2024 regarding the viewing of the state's physical evidence as tendered in open court on August 9, 2024. The state shall prepare for all parties to execute a notice reflecting when the evidence viewing took place and the length of time that the evidence viewing took place. The state shall file with the court the executed notice after the viewing of the state's physical evidence takes place. Defendant's request regarding extending the laptop time has been agreed to by Orange County. The times have been extended as follows: Sunday through Thursday, 8 p.m. to 10 p.m., and Friday and Saturday, 8 p.m. to 11 p.m. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department Security Operations, which was previously provided to Ms. Boone and read to Ms. Boone. Defendant's request regarding the discovery that was provided to the court on June 28, 2024, and keeping that discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14, 2024, and the balance of defendant's requests cannot be accommodated for the reasons placed on the record on August 14, 2024. Ms. Boone, you'll be given a hard copy or hand-delivered a copy of these orders momentarily.
Thank you.
All right, anything else? Anything else, ma'am?
No, Your Honor.
All right, thank you very much.
Thank you.
Deuces. Oh my God, you guys. Oh my God. Oh wait, let's look at the end. Just kidding. Oh, okay. They cut it. Oh my God. You guys. What was that? What was that? Let me go to I start some of the comments. So DB. Ooh. Hang on one second. I hope that didn't blast your ears out the way it blasted mine. Hopefully I had it on mute for you guys. I want to remove it, stop screen share, because I had it up super loud so we could hear Sarah, and then it was like, anyway. What if through poor time management and personality conflicts, Sarah begins to run through the 10,500 too quickly? Are those funds unlimited? Just wondering. They are not unlimited based on what the guy from JAC said last Monday. However, she can submit and request more money. I'm imagining she has to show cause. I think she's gonna go through money pretty quickly. I think the JAC knows that too. That's why they doubled it like that day of the hearing. But I do now feel bad for Mr. Lane. Yeah. I bet this is how she treated her boyfriend. So Dark Mankind, I think it was even worse because she had complete and total control over him in that he lived with her rent-free. He didn't have a cell phone, so he needed to use her cell phone. She supplied his food, groceries and liquor. And in one of the interviews, the brother said that they used to bicker about eating because Sarah would keep getting more like, is it drunker and drunker? And he would be like, we need to eat, babe. We need to eat. So she is not a big eater, or she wasn't. I mean, it seems like she's doing just fine. Sorry, guys. I'm nasally. I apologize. But so they would argue about that. And then we heard also that from Sarah's own mouth that she cut short, or maybe it wasn't, the night that he was unfortunately unalived. He had been talking to his daughters and she rushed him off the phone so she could talk to her son. So she had complete control, right? And we know she's a manipulator. So imagine, like, he was literally at her beck and call. The only thing he could do would be to go back home to his mom and dad's, which I have thought about this. And I think maybe because he was an alcoholic, they probably didn't let him drink in the house. So because that addiction was there, it led him back to Sarah's house. And also, which, oh my God, it scares me now. We heard from the brother, she would always beg him to come back. And we can see she is super persistent. And if he was a weak man, or he had a soft heart for her, or a soft spot, however you say that, he went back. And the alcohol, so it was, I can't even imagine what that poor man went through. He might be free now, you guys. I mean, I'm not saying he should have been unalive, but oh my God, if he couldn't break that addiction to get away from her, he might really just be free right now, enjoying, as Kathy would say from Gossip Rumor and Innuendo, the endless buffet in heaven. Why did she just ask him to put her through? Why didn't she just ask him to put her through school to become a lawyer? And that is exactly how ridiculous she is. Totally. And she should have been studying. She's been in there for 4 years. Do you know what I'm saying? Like, I would have done so much research. She sounds super disorganized because, one, they sent you 9 pieces of digital evidence that the investigator carried into you, and you reviewed one of them, and it sounds like you're waiting for him to come back. I would have, at the minimum, opened up each file to confirm the state that they were in and they were actually accessible to me, so that when I showed up to this hearing, I could say, of the 9, these 2 are not working, and not sitting there like she did the last. Oh, the majority of them. Well, the majority is like 51% or more. So are you saying like 51% of the files don't open? And then she was kind of accusing the state of doing it, but the state, those original USB thumb drives, the state didn't do that. Mr. Lane did that, right? And so it's like she's kind of all over the place, but she's so paranoid of like people are out to get her, people are doing nefarious things against her. People are trying to, we heard in this hearing, like she's trying to keep it confidential. So that's why she wants the USB drives at her that's silly. The control room sounds way more secure than, I can't imagine this is like some heavy duty drawer with a heavy duty lock on it, right? So it just sounds silly to me. And who knows, like maybe when another inmate has a key to that one, like some inmate was getting released and slipped the key to another inmate and was like, oh, told the jail, oh, I lost the key. I mean, maybe they rekeyed it, but it's just like too many like unknowns to risk it. And I'm with Miss Gina D. Giovanni. Like, why do you need the hard copies? Why are you hesitant to go into the shoe? Right? Why does she need the hard copies? Huh? Oh, okay. You want to sit over here. It doesn't make any sense. Like, I cannot track her logic. And then I was thinking about it too. So, when she said in court, like, she could, what did she say? The icons came up. So she's not super computer literate, because you know how you can change the list and it'll show you all of the files. It'll show you the file type. It'll show you the last time it was touched, when it was created, who created it, like all that metadata is in there. So when she was like, oh, I don't know what it was, I just clicked on the icon. Again, like, make it a list view and then go through and write down specifically the ones you can't see. What do you mean you didn't want to waste your time? Girl, all you got is time and your life is on the line. You know what I'm saying? Like, make it make sense. I do not understand it. I don't understand it. And then I hate to say entitlement because it's so overused, but she is the walking, talking epitome of entitlement. She doesn't say thank you. Like, when they're giving her what she wants, she's just like, okay, but she's not like gracious about it. And then imagine being the captain, right? So you left for vacation with clear instructions on her having digitized discovery, the laptop, very clear rules, protocol. It was all written out. It was handed to you, so there's no confusion. And you keep asking for paper to the point where everybody relented. Then the captain is coming back from vacation. She's got to meet with the judge on Wednesday, and then she's found out, like, she seems like a no-nonsense woman. She's at risk of violating the fire ordinance, and now she said it on the news. I mean, I know everybody's not watching, but she's got to get it rectified immediately. She can't claim she didn't know. I'm sure she's gonna have a strong talking to whoever let her have those boxes in there. And I am like grossed out about boxes laying around, because don't they attract bugs, or they come in with bugs? I mean, I'm sure Mr. Lane didn't have bugs in them, but like a bunch of boxes kind of weirds me out. Yeah, I'm like, she said she had 2. So she sent the letter that the captain was reading, right? And she was saying, like, I'll put them in the bag and I'll purge things and da-da-da-da. Yet the first thing out of her mouth today is the 2 boxes are sitting by her bunk. That is not discreet. And who knows? Like, the guards are not going to stop other people from going through your boxes. They have important things to do. You know what I mean? Like, protecting the safety of it. They're going to assume you knew the risk. You assume that risk. she just doesn't mind putting people out. And then she was like, we could I'm imagining the property place is secure when they're talking about moving these bags. I may be wrong. So every time she asks for it, somebody's going to have to go and do it. And they're not going to be able to hop to it like at her whim, right? She's not Pretty Woman. There's no beck and call girl. So I just feel like that would be a problem. Like, I appreciate Captain DiGiovanni being gracious, but I feel like that's going to backfire, that no good deed goes unpunished. That's what I feel like. Okay, hold on. I want to show you guys a couple of these because the judge already had this ready, which tells me he already decided walking in. And I trust this judge. I feel like he's more than fair, more than documenting everything that has to happen. So here's one of the orders. It is dated 8/14. Let me make sure you guys can see it. Okay. Hopefully, let me go back to where you guys are. Uh-oh. Dang it. I have a Band-Aid on my finger. My MacBook is mad about it. Okay, so here, ouch. I don't know why he likes to pull my hair. Okay, you okay? You okay? You're sleepy. Okay, let's get into this. So this cause came before the court on August 14th, 2024 on the court's order and notice of hearing entered August 9th, and the court having reviewed the defendant's August 7th letter provided to the court on August 9th. Having considered the arguments offered by counsel for state, having considered the arguments offered by counsel for defendant, i.e. Sarah, Boone Esquire, and having considered the arguments offered by counsel for Orange County, hereby orders and adjudges as follow. Defendant and state agreed to an alternative arrangement as placed on the record on August 14th regarding the viewing of the state's physical evidence. So the bat, the wine bottles, the suitcase, the tie that has blood on it. I think the bat had blood on it too. There was a pillowcase with the stain. So all of that physical stuff she's going to be able to see now at a different location. So it's not considered a hearing. So there is no requirement for the media to be there because it's not a hearing, right? Defendant's request regarding extending the laptop time has been agreed to by Orange County. The times have been extended as following: Sunday through Thursday, 8 p.m. to 10 p.m. and Friday and Saturday, 8 p.m. to 11 p.m. Now she's asked for this time, but this is even the time that she's had, right? Because she has the access to that laptop even on weekends. And so she got the laptop last week, Tuesday, right on the 6th. And what are we today? The 14th. And she hasn't even opened up much of the discovery. And she also has the paper, and she keeps, or you guys tell me if I'm mishearing it, she keeps alluding to she hasn't had time to go through it all. I would at least put hands on it because she's accused so many people of things missing. Like, what else are you doing all day? Like, seriously, nobody's accepting your phone calls. Are you playing pinochle? I wouldn't sleep a wink until I went through all of it, but that's just me. And I also wouldn't lock anybody in a suitcase and go to sleep, but that's different. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department. I mean, literally, all she has to do is look at this discovery, right? She's not, oh, maybe she's writing more letters. She did submit something, right? The JAC letter. But focus, girl, focus. And is she going to have time? Maybe that will be an allowable reason for extension, but I don't want it to get delayed. I want the first week to be her birthday to land in the first week of the trial. I think it's super fitting since George died the week after his birthday. So defendant's request regarding the discovery that was provided to the court on June 28th and keeping the discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14th. The balance of the defendant's requests, Word document, an office, i.e. classroom, telephone, unfettered access, the USB drive at her drawer. I can't remember the other. I think there was 5. Anyway, so that is what was happening. And then let's see, I opened up these other ones. Oh, here it is. Yes. Okay. Share this tab instead. Can you guys see that? Okay. Yeah. So this is, whoops. Here we go. This is the word I was looking for. Ore tennis. That was what I think it was Mr. J explained that would be an oral motion. So an oral, it started as oral because she just said it out loud in the court, right? That she was worried about fairness, and then her argument was meant to be oral because she didn't have any papers to rely on. When you do a written motion, you can document and cite all your cases on the written. So actually the oral is easier in my opinion. But she still should have done the research on what she was saying when she was like, it's my understanding that it's not fair and I have a right to privacy. Like, well, ma'am, what case law gave you that? Because Florida, and I love Florida for it, is wide open. Sunshine. Let the sunshine. Okay. This cause came before the court on August 14th on defendant's Ore tennis motion. I didn't take Latin, so don't kill me if I said it wrong. You can read it here. You said however you want to. For closure of the state's physical evidence viewing with the state and defendant set for September 3rd at 9 a.m. requested on August 5th and on August 9th on WF TV channel 9's motion to intervene for the limited purpose of opposing. We'll just go through it. And then also the Orlando Sentinel. So it just says, and having considered the arguments offered by counsel for defendant and having considered the arguments offered by counsel for intervening parties, WFTV TV channel 9 and the Orlando Sentinel. I need to talk to their branding manager. What kind of name is this? WFTV TV channel 9. I would just call it WTF TV in my opinion. Anyway, so this, you see how it came in at oh no, this is not it. I'll show you the other one. This is the judge's order, so that came in. But what the Sentinel put in, it came in today. So the prosecutor got it today. Like her whole situation of like, I'm just getting it today has no validity. Defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Pub Company versus Lewis. And we talked about that yesterday. There's a 3-prong. It has to meet all 3 of those prongs. She didn't meet one other than it wasn't fair. She is, whoever said that, toddler. I think not a toddler. I think she's more like, when did you stop being a toddler? Like she's like a kindergartner. She wants it to be fair. My mama told me life ain't fair, and I rolled with it. The defendants requested closure of the state's physical evidence reviewing with the state and defendant set for September 3rd at 9 a.m. is denied. But so because she already knew that she had an agreement with the state, she could have just withdrawn this, right? And it would have, because it's effectively moot. However, I think the state is okay with it being answered because like, the attorney Jay said, anything could happen. And it could be another thing like how she's negotiating with the boxes and I will put them in a secure, oh, I didn't know they were fire retardant. Who cares what you do? It's libraries filled with shit you don't know, honey. It's many things filled with, what did she say? It was my understanding. Okay, well, you understood wrong. Next. So that was that. Let me go back to the Orange County website because I want to show you the filing that came in today from the Sentinel. Because actually one of you guys put it in the comments. You may not be here now. If you're on the replay crew, drop it down below. I appreciate you for coming to watch via replay. Okay. Here we go. This is what I want to show you guys. So this one, e-filed 8/14/9/39/25. So that means the state got it today, this morning. Everybody else got it. Now, maybe she had some hours that she didn't get it. But, I mean, what does she want them to do? She says she gets up at 3 o'clock. I don't know. I just think she's full of it. Like, anything that she feels is unfair or that's different, she's, like, really hung up on fair. And I feel like, I don't know, fair can be ambiguous. Fair does not equate to equal. And I think she wants to be equal with those attorneys and not with other pro se inmates, you know? And that's why she was like, can I have a list of what they are? Because she is one of those ones who is like, gonna look at the rules. I mean, and I do it too. I'm not faulting her, but she does it for a nefarious reason. I'm gonna look at the rules and I'm gonna figure out like how do I get in between them, right? Without violating. Like she's gonna take it. What is that? Yeah, take an inch. If you give them an inch, they'll take a mile. She's taken miles. So moves to intervene in this action for the limited purpose of opposing closure of judicial proceedings. The Sentinel is a daily newspaper of general circulation in Central Florida, which has reported and continues to report on this instant matter, meaning the one in front of the court, and relies upon judicial proceedings and records as part of its news gathering process. The Sentinel has standing to intervene and oppose any requested closure of these proceedings and joins and adopts the motion to intervene for the limited purpose of opposing closure filed by WFTV. So they joined it, right? They just piggybacked off of it. But again, it was filed this morning. So everybody got it today, Sarah. You had it for a few less hours, but I mean, how that's a paragraph. And it because it's adjoined to the other one, whatever arguments you had, it was irrespective of who else intervened, it would still have to stand on the same case law. And you came with nothing, nada, zip, zero, zilch, other than your feelings and your understanding. But that's not fair. Okay, Sarah. Okay. Yeah, that's it. Just I don't get it. I don't get it. So those are my 2 cents for the evening. I'm heated. Like I can't win Miss Boone. I cannot. I don't know how they do it. Oh yes, I think she is gonna snap. You see, she's at the point. She's a short fuse. And then that mouth goes like, girl, ma'am. Pay attention, Sarah. They're offering her a private room with a phone and a shower, and you're complaining about the classroom. Take it, girl. Yeah, definitely. I don't know why she doesn't take it. Like, and you could be up all night with these papers or whatever you want to do. You know what I mean? Like, she's focused on the wrong thing. Anybody with like ADHD, do you think those are symptoms of ADHD? I'm like, oh my God, I wish I could crack her brain open. She's a legend in her own mind, but we all know alcoholics are narcissistic, irresponsible. Are they? I did not know that. My dad was an alcoholic, and that definitely fits. May he rest in peace. The court may need to start delivering signature required docs. USPS is not cutting it, right? But it's moving so fast too, right? There's a lot going on. So the judge can't control how long it takes to get there. He can't control that Sarah's going through 8 lawyers. It is now waived/forfeited her right to a public defender. You are where you are because of your own actions. Hi, Sarah. Meet boundaries. Sarah, meet consequences. They're going to be your new best friend going forward. Oh yeah, the lawyer, he was having none of it. He was like, did he say it's my understanding? I don't remember, but she's went through no less. And he was the 8 lawyers and the courts, meaning the higher courts, don't, whatever it was, like don't give much credence to defendants like her, basically. I'm summarizing, but you know, you heard him, you were here with me. So yeah, I was like, oh my God, he is giving her the here for, the what for, and the here now, or however you say that. I'm like, oh my God, what happened? What just happened? And she got heated. So also she's showing the prosecutor how she's going to behave in court, right? You want to keep a cool face, just like in like business meetings, right? You can't be in there like with steam coming out of your collar, because then your opponent, you're showing your hand, as she said, she wants the best hand possible. Yeah, that's your tell, and you have nothing but your emotions. And imagine her getting mad at George. I just feel bad. Like all of this he had to endure. God bless him. Maybe he just stayed blitzed out of his mind so it didn't bother him. That lawyer might petition the court to have her unshackled so he could fight her in the parking lot. Oh my God, nobody wants to fight her. Lord have mercy. She would have strangled that man. All right, we've been on here. I'm still loud. Did I turn this down? Sorry, guys, if I'm blasting your ear out with my congested sound. Yeah, let me, you see Sugar Bear's hit me with the pillow. He wants a pillow fight. Let me go attend to him and nurse him and get him to sleep because it's 9 o'clock. So I appreciate you guys coming and hanging out with me. Oh my God, this was a doozy. Like I might have to cover the trial. I don't know if I could do it live. I'd have to take off work, but maybe we recap at the end of the day, or maybe I like edit some cuts out, but we have to cover this. The ridiculousness is off the charts and is taking so much away from George and his family. Imagine his mom seeing this foolishness today, like her demanding a Word document and a telephone and an office and a printer right? Ultimately, she says she wants a printer because what else are you going to do with the Word document? A printer, paper, like we don't even know if the captain has all that. And the captain is like, might as well not have gone on vacation because she didn't come back and all hell's broke loose. People aren't following her orders, and Sarah's going to give them a run for her money. If nothing else, she's going to make it painful for them, right? It's not going to be easy. But I think the state is ready. I think Judge Koenig is ready, right? You got your Dr. Pepper ready, Judge Koenig over there? You ready? Oh my goodness. Let more people into your break room so she could get that attorney. I can't even say because my nose is congested. Okay, you say goodbye to everybody. Say bye. Bye. See you later. You say see you later. Say bye. You said, Mom, shut up so I can get a word in. Okay, say it again. Say bye. All right. I love you guys. Thanks for rocking out with me. I will see you guys later. Toodles. Bye, everybody. Playback crew, leave your comments. I'm looking forward to talking to you too.